Great. All right, so we're ready to move on to our second panel, Players' Rights, NIL, Trademark, and Athlete Advocacy. I'm going to introduce the three people up here, and then we'll start. So the first is Kevin Kennedy, who will be our moderator for this panel. He's the president, co-executive director, and founding sponsor of the California Legends Collective, an NIL platform created to empower UC Berkeley student athletes to secure name, image, and likeness income opportunity. He was previously spent more than 20 years as a partner at Simpson Thacher and Bartlett and served as the global head of the firm's technology practice, advising on major capital markets transactions, including Tesla's IPO and Apple's record-setting bond offering. Our first panelist will be Jogith Bullard, who is the Deputy General Counsel for the San Jose Sharks, where he advises on a range of legal and business matters across organizations. Prior to joining the Sharks, he spent more than 5 years at the Pac-12 conference, negotiating sponsorship, media distribution, data rights, naming rights, and venue leases and talent agreements. He also earned his JD from UC Berkeley Law, which I'm very glad to hear, and he brings background in engineering and contract negotiations to his work in sports and entertainment law. And then our final panelist is Marshall Sherrington, who is the Assistant General Manager of Cal Football, where he oversees recruiting and player personnel, roster management, and revenue share cap. He has worked in college football for more than 11 years and was named the 247 Sports 30 Under 30 list in 2023. This offseason, he's assembled a top 12 ranked transfer class in the count. So thank you all for coming here, and I'll hand it over to Kevin.
Great. Well, thank you very much. Pleasure to be here. We had a third panelist, but there wasn't enough room at the table, so they bailed out. So it's just going to be the three of us. So I had set this up to ask some questions about, the legal framework for NIL, but instead I'll give a little talk here for a couple minutes. And many of you are probably familiar with this already, but just to set the groundwork for kind of what created NIL and how did this happen. There's really three pivotal events. And then we got to the House settlement. The three that led up to the House settlement were the Banyan case in 2014, which was a student athlete, made the observation, hey, I played this sport for my school, and now my name's on this video game, and EA is making all this money off of this, and the school is making this money off of it. I'm not getting paid anything because at that point it was illegal. That case went through, and eventually Ed Banyan won that case, which kind of started to open the cracks. Then you got to the Alston case, which again some of you are probably familiar with as well, on kind of a secondary or tertiary issue for financing athletes. But in this case, and it's important, and this was in 2021, I believe. Justice Kavanaugh, from the bench, just had one of the great concurring opinions of all time, certainly for athletics, where he's like, the NCAA has no basis to exist. There's no legal framework that you can justify what they're doing. They don't have the right to tell anybody how much they can get paid or if they can get paid at all. They don't have the right to say eligibility, how many years they can play. There's no antitrust exemption for the NCAA, so why is anyone listening to them? Well, you can imagine how that went, because then, of course, every plaintiff's lawyer in the country started rubbing their hands together because they knew exactly what was going to happen. And then, of course, UC Berkeley, or the city of Berkeley at least, had a very seminal role in this because SB 206, which was the first state law kind of authorizing NIL, was penned by our very own Nancy Skinner, who I think, I just was talking to someone yesterday, Nancy didn't exactly know what was going to happen when she did this. I don't think this was really her intent. But of course, once you started authorizing paying athletes, there was no limit, and so we went into the era where it was all holds barred before the House settlement got finalized, which just happened this last summer. So that's kind of where we stand right now, and right now we're standing in this moment in time where you have these three very important court cases, or two important court cases, and then of course the SB 206, and then of course the House settlement, all of which kind of set the framework for what's going on. So I think the question I was going to ask, but I'll ask myself instead, was, are we done? Is this over? Is there any reason to expect this is ended? And I'll give the answer. I think the answer is no. There's no actual, because of what Kavanaugh said from the bench, and because of kind of all the various issues that anyone who's looked at this has identified, again, the reason that the NBA can do what they can do, the reason the NFL can do what they can do, the reason the Sharks and Major League Hockey can do what they do, they have an antitrust exemption. And why do they have an antitrust exemption? Because they have employees. So they can collectively bargain for salary caps and limits, and they can limit people's salary. Well, in Justice Kavanaugh's words, we don't in America have rules where we say cooks don't get paid because they have to cook for the love of cooking. That's just not the way the world works. No one has the right to tell a student athlete they can't get paid for this work that they're doing that is actually generating billions and billions and billions of dollars for the universities. So for a long time, you had universities competing by doing crazy stuff like building these mega sports complexes and paying coaches $10, $11, $12, $13 million a year. That stuff's still all happening, by the way. But now we're actually seeing some money actually siphoned off for the athletes who are really generating this revenue. So what's happening right now is that you have everyone's kind of looking at Congress saying, Congress, what are you going to do about this? Because really, who can give an antitrust exemption? And it's only Congress. There's nobody else who can do it. Now, Donald Trump thinks he can. He actually said last week he was going to issue an executive order. It's going to come out right after his health care plan. So I'm sure any day now will be. He's actually already issued one executive order in this area, and everyone just kind of ignored it. I'm sure he may do something else. But you have two different competing pieces of legislation going through Congress right now. You have the SCORE Act, which is really which grants the antitrust exemption. And it's really sponsored largely by the Republican caucus. And then you have the SAFE Act, which is supported by the player unions and really largely sponsored by the Democratic Party. And that one doesn't have an antitrust exemption, so I'm not sure how it actually fixes the problem that we're trying to deal with right now. But nevertheless, those two pieces of legislation, and they're kind of stuck in committee. They've never really gotten even close to a House floor vote. And you have the president saying he's going to issue antitrust exemptions, or he's going to issue executive orders to grant an antitrust exemption, which of course you can't do by executive order. And then you have another piece of legislation which is kind of out there right now. So long story short, I think the one thing to expect is more chaos. Until such time as you actually see a piece of legislation on the federal level that's going to stop this and kind of rein this in, there is no basis to believe that the House settlement, which dictates, we talked about earlier in the last panel, the $20.5 million cap being paid to every student, right? So the House settlement says $20.5 million being paid from the school. All their students collect, all their sports combined. No school can pay more than $20.5 million. And even that's people say that number all the time. That's not exactly right because it's actually based on a percentage of your revenue. But for these purposes, let's assume it's $20.5 million, and a school like Cal can qualify because we have enough revenue in order to generate the $20.5 million we can pay to our student athletes. But then you have, on top of that, so-called above the cap payments. And that's where we're going to pivot now. We're going to talk to my friend Marshall here to talk about this. So Marshall, you have the settlement right now. The House settlement is in place, and $20.5 million is the maximum that Cal can pay. I believe Cal has stepped up and actually is paying the full $20.5 million.
Yeah, absolutely. No, it's a new age for sure, and our administration's done an incredible job of being able to support us with everything we need in terms of the revenue share side, and us specifically with football. We've been given full breadth in order to go get what we need, and that's the revenue share side. That's opening avenues for third-party payments as well, and that's what we're seeing a ton of right now. Is like there are numerous $40+ million rosters in college football, and that's those numbers are getting close to $50 million, and that's just for 1 year. That's not like multi-year rosters. That's just a one calendar year spend. So what a lot of these teams are doing, and you have to do this to keep up with the environment we're living in, is go find these above the cap strategies. And above the cap strategies is basically finding these third party external deals for your players with certain brands and companies to create these natural NIL deals and be able to organize it and, connect the parties at hand. You can't guarantee anything to these student athletes. And, we just went through the transfer portal a couple months back in January. It's super hectic time. But what you can do is you can talk through with those student athletes is like, these are the connections that we have. These are the companies that we work with that have done deals with our athletes in the past. You can't be like, okay, we got a $100,000 deal for you with this company that's guaranteed, all locked up. You can connect the dots. It's up to them to fully execute that deal. So as part of that 20.5 mil, usually about 75% of that is to football, especially at the Power 4 level. So you can imagine how much above the cap, third-party deals are being done. If you have $15 million through rev share for these players, if you have a $40+ million roster, that's $25 million plus in third-party deals. So that's a lot to coordinate. That takes a lot of alignment on the administrative side. That takes a lot of connections. I think that's what's an incredible part about being here at Cal is all the different connections you have, naturally just geographically with where we're located, but the alumni network throughout the world. So that's what we're seeing a ton of, and you're going to continue to see that, more and more as if the landscape, sticks with how it looks like right now.
So Marshall, let's get a little bit more into that if we could. So you're talking, we have the 20.5 million coming from the school and rev share. We have the above the cap. Like what percent, you see this every day, what percent of schools do you think who, in the P4 level, like at which Cal is, are actually doing, any above the cap? Because 20.5 million is a lot of money just for the school to come up with by itself. How many people are doing above the cap payments?
Yeah, that's a great question. If I had to estimate it, I would say at least about 60 to 70% of schools now are doing these above the cap deals, if not more. I mean, I could be a little low, if anything, on that end. So I think a heavy majority of these schools are doing these above the cap deals. You have to if you want to be competitive in this landscape, if you want to make the college football playoff, which I do think there will be expansion to in the next couple of years. It's only going to get more competitive with teams on the cusp of it. So obviously there's more money in college sports than there's ever been before, and creating such a competitive landscape, especially in like conferences that we're in, the ACC. Like anyone can go out and win the ACC. Like you saw Duke go win the ACC last year. They obviously didn't make the playoff, but it's a conference that very winnable. And now moving forward, the conference winners get automatic bursts into the college football playoff with the new system they're implementing. So I think that competitiveness is just driving this above the cap type area and space. And you see it with a lot of the companies around there too. There's a lot of agencies being formed for just third party above the cap activities. You see individuals coming out of the woodworks. We get hit up about it dang near every day. But I think that's why I go back to being aligned, being on the same page about the strategies with how you approach this with is critical. And you see it on the basketball side too, just talking to those guys and Coach Madsen's staff, like they see it a ton in college basketball. And it's interesting because you have different schools that are, basketball schools. You have like Gonzaga, a school that doesn't have a football team, so they have a lot of that revenue share cap space to be able to use just strictly on basketball. And that's why that space is even getting more competitive because you have schools like that. So heavy majority of schools are doing it now, probably low end. So at least like 65, 70%.
And then in football, like when you're looking at the top third of the conferences, and it's probably not uniform, but if you're talking the ACC, the SEC, the Big 12, the Big 10, how much are we talking about? Do you have a sense, like, are we talking $2 million above the cap? Are we talking $5 million above the cap? To get into the top third of those conferences, how much money exactly are you looking at?
Yeah, top third of these Power 4 conferences, the Big 10, SEC, Big 12, and ACC, I would say at least that over the cap spend has to be at least like $7 million, $8 million to get in that top thirds of those conferences. Obviously, the SEC and Big 10 probably a little bit more, just because, I know Jenny mentioned it, just those media rights deals that those schools get and generating the revenue on that side. So I would say, at least $7 to $8 million to get in that top third of the conference.
Right, and I believe just for the benefit of the audience, so this has to go through this process, the CSC, which is the NCAA's body that they set up to oversee the house settlement, which is supposed to, NIL Go is the platform, but they're supposed to approve every one of these above the cap payments. So what the school pays, of course, is you can pay any amount. Right, or they're not going to. If you want to take all your money and give it to your quarterback and nothing to anybody else, I wouldn't recommend that. But you can, right? But when you're talking about anything above the cap, anything that would exceed the 20.5 million is coming from a third party, it's got to go through this NIL Go process. The thing that is not, though, I think as well understand is that's true in general. That's not true for public companies. So if Nike wants to do something or Pepsi wants to do something, they don't have to go through NIL Go. There's no limitation on that. So Marshall, I guess, are you seeing that as well? Are you seeing like the Nikes and the Pepsis of the world kind of getting involved in making these payments to student athletes?
Yeah, and I think those larger companies, it's really in our world, we call it real NIL because it's like real, like significant athletes with hundreds of thousands of followers getting deals from like a Nike or Pepsi. A lot of these other deals, are arranged and stretched a little bit, but you definitely see that. And that's huge. And like Kevin said, this NIL Go clearinghouse process, that's deals above $600 that have to get cleared by this third-party group. And now, the group that the NCAA designated for this space. And now, I don't know if you saw it, Kev, but that Nebraska deal is like the NIL Go clearinghouse kind of put a stop to this deal for 18 Nebraska student athletes. And I think the totality of the deal is close to $2 million for that group. Got denied, and now there's going to be a lawsuit against the CSC and then NIL Go clearinghouse. We'll see how that goes. Me and Kevin have been talking about this for probably 2-3 years that this was going to happen. So it's kind of the first real test of that whole process. So I think you could see even more change here soon.
And the problem being, of course, like as we talked about, there's no there. The emperor has no clothes, right? There's no antitrust exemption. So really, the entire house settlement structure and NIL Go structure, there's no legal basis for it. And this is an area where when I was practicing, this is something I spent a lot of time on, is antitrust law. You don't really have a foundation under which NIL Go can operate. And you can limit people and stop people like the Nebraska players from getting paid. And so the question is, well, it's going to last until someone challenges it. And this is going to work its way through the system. You hope that at some point Congress kind of gets something done, but I'm not holding my breath. We'll see. So let's pivot over here, Jagoff here, and let's talk about. So we've talked about what's happening at the college level, and I'm kind of interested and curious how this is impacting pro teams. Are you seeing players coming out of college now with kind of different expectations about, how they're going to be paid or even the form that payments are going to take? Is this starting to trickle into your world?
Well, I'll take a step back. I always say in the sports world, if you're ever confused about a headline, you can default to two different principles or headlines. One's about advertising and one's about television revenue. You heard about television revenue in the first panel, and why the Pac-12 broke up is because they couldn't get a great TV deal. USC and UCLA jumped to the Big Ten because Fox was their TV partner, and they 2.5x their TV deal, and the rest of the Pac-12 dwindled from there. To your question, is that second prong of advertising. So if we go back 20 years prior to the iPhone, how did brands advertise? They would advertise around large events, the World Cup, the World Series, on big billboards that would maximize viewership. So if you knew I can get 100 million people watching this game, X% of those people will convert to be brand purchasers. The iPhone comes out in 2006, and all of a sudden brands have a direct relationship with their customer now. Facebook and Google invent the metapixels and the ad trackers. Now I know how old you are, what school you go to, what you like to eat, and more importantly, what you don't like. So if you take that to its full extreme in 2026, we've got microeconomies and micro-attention spaces rather than national advertising. And I think that's what's happening in parallel with the NIL world. In hockey, I think hockey is a great example of how NIL is going to change NCAA hockey. So if you were a 14-year-old superstar hockey player, you could have always played professional junior hockey. There's 4 different leagues you could have played played in at 15 years old. The Ontarian Hockey League, the Western Hockey League, the U.S. National Hockey League, all of these are junior professional leagues. In 2025, in August of 2025, they changed the rules so that even if you played as a professional junior, you could then go and play in the NCAA. So the NHL draft is coming up in June, July. Gavin McKenna is a projected number 1 pick. He is playing at Penn State right now. He also played pro juniors prior to that. That's an example of how it's going to affect the NCAA. Is you'll start to see hockey players embrace this idea of NIL. Hockey in America, the majority of hockey players come from 3 states, as the hockey fans know. It's Minnesota, it's Massachusetts, it's Wisconsin, and a few others contribute to the national team. And hockey's always been a grassroots sport about team first. If somebody gets hit on your team, you drop your mitts and you fight. It doesn't lend itself to being a creator or building a brand or having an identity in that way. But I think that's going to change. You'll see it with Gavin McKenna, who is this next-gen prospect who is starting to make NIL money at Penn State, so that when he's an NHL star in 10 years, he's not going to be like a Sidney Crosby, maybe, who's soft-spoken, a winner, team mentality. He may get obsessed with his own brand and want to do bigger deals. I think that's where you'll see the shift in hockey.
Do you and certainly you're seeing this on the basketball side and also on the football side, where players are actually electing to stay in college because what the money they can make. I mean, I suspect that Oregon's entire returning football team, their starters all essentially came back because they could make more money at Oregon than they could actually in the NFL. Are you seeing that at all? Is that discussion happening where people are like, I think I'm good here in college for a little bit longer?
I think that's a great point. I'll give you an example at the San Jose Sharks. So the Sharks haven't made the playoffs since 2018-19 season. We've been rebuilding. For the past 4 years, we've been in the top 5.
It's like Cal's been doing it for 65 years.
That's right. But we're coming back. We're coming back. Michael Misa was our number 2 pick last summer. He played in the OHL. He chose not to go to college. Macklin Celebrini played in college. I think now if you're an 18, 19-year-old hockey player, the Stars will always operate based on the traditional rules, I think, because if you're the number 1 pick, you've got a great chance to play in the NHL immediately. If you're a 2nd or 3rd round pick, your choice is, do I go play in the minor leagues in hockey? I may not get called up. I may not have a massive salary. The best players in hockey make $17 million. Connor McDavid makes 12 or 13, and he's the LeBron of hockey. Now imagine how much the minor league hockey players are making versus if you're one of the biggest stars on Penn State's campus, and the NIL, cap that you mentioned, the 20.5 portal, you can get access to that, build your brand. I think what we'll see also is a bifurcation between athletic success and brand building. Sometimes the brand comes from being great at the sport, but it doesn't have to. It's not a necessary condition anymore. So you could be a hockey player who's got great hair and you look like you could be an actor, whatever the case may be. You go viral on TikTok and you become this heartthrob on Penn State's campus. You might be the highest earning NIL person on that campus, even compared to the football players.
Well, it's probably bears mentioning that probably the top earning, maybe not last year, but the year before that, the top earning NIL athlete in America was Livy Dunn from LSU's gymnastics team. And it wasn't because people were really obsessed with LSU's gymnastics team. But you couldn't turn on the TV without seeing Livy Dunn. And she was one of the earliest beneficiaries of kind of brand building. She has, tens of millions of followers on everything else. But what's interesting for me specifically on hockey, and I think you saw this, some of you might be familiar with the story, but last year Stanford lost its starting softball pitcher, the heart breaks for them, but who went to Texas Tech. Which is not usually, you don't see a lot of people transfer out of Stanford to go to Texas Tech, and it was because she got paid $1 million in NIL to go there, and so what you had someone who was just a super fan of softball, and they were willing to actually put that money on the line. So you have to imagine that in hockey, similarly, you could have an incredibly well-heeled person comes in and says, I'm really a huge fan of Penn State's hockey team. This guy, we're going to take the championship next year. If I can keep this particular player, I'm going to make it his while to come here.
Yep.
Yeah. So you can imagine that.
Well, I think that idea of I think the idea of teams is going to change quite a bit. We're already seeing a macro trend in the world in general of individualism and product of COVID and anything else you want to blame it on, of people having micro interests and having niche communities. That may lend itself to sports. And in the hockey world, I mentioned it's always been team first and tight knit community, and the team is above the brand. I think it differs in every sport. If you look at the NFL, there's 50 people on an active roster. They have helmets on. The shield is meant to be more important than the individual. And in basketball, it's very much about the star, and they've leaned into international branding and everything else. I wonder what's going to happen to hockey with respect to this team idea. And hockey players shift off the ice every 50 seconds to 70 seconds. It's just a different sport completely, but it may shift culturally in the next 10 years.
Well, and so the last question before we open up for Q&A for you, though. So, this is an area where it feels like college needs to follow kind of the pros. If you have a hockey player, for example, you're an Anheuser-Busch, franchise. I don't know what your beer of choice is, but whoever, they're paying a lot of money to have their beer sold and have them advertised on the ice, et cetera. And now you have a dynamic where you have a player coming out and they say, Modelo or Bear Brewing or whoever, right? And they're getting a brand deal. And so the schism, I would imagine, maybe you're already seeing this. The tension between Anheuser-Busch is like, whoa, we're paying for the team. Right, we're paying for the entire team, and your individual players going off and now getting a brand deal. That doesn't work for us. That's happening on the college side, and it's problematic on the college side. But you guys, I imagine, have ways of stopping that on the pro side. Yes, is that?
That's right. You mentioned the antitrust exemption, which is a collectively bargained agreement, and I think in the NHL you have. I'll give you an example. So we had a bobblehead giveaway 6 months ago it was projected to be with 3 of our players: Tyler Toffoli, Macklin Celebrini, Will Smith. We get a note from the NHLPA about 2 days before the actual game. Of course, all the bobbleheads have already been made, all the marketing's been printed, tweets have been sent out. They said if you're going to have a marketing giveaway like this with 3 players, you need NHLPA approval and you need it in writing, and we have to draft a contract. We didn't think we could get it done on time. Yeah. But the way the NHLPA is written, or the collectively bargained agreement is written, is if it's only 2 athletes, the team can do it without the approval of the NHLPA and the league. You just need the players' approval. And for the most part, we have implicit approval based on their likeness agreements with the team to do existing deals with existing sponsors. So we changed the bobblehead, and we took out the third piece and made that an add-on a premium purchase, and it got it approved. And I think that's one example. The other aspect that you mentioned of brand synergies, Macklin Celebrini signed a deal with Sony Beats by Dre. They're our existing partner. I think you'll see a lot of that, of teams nudging their existing partners to go ahead and upsell and engage with their brand. Because the reality is, a deal with Macklin to the public consumer may feel just the same as a deal with the Sharks. And we can choose to lend our logo, whether or not it benefits us. But I think that's what we've seen so far.
Yeah, interesting. Well, I think, so maybe I should open it up for Q&A. I know they wanted us to leave about 10 minutes for people to ask questions for the panel, so.
I have a hockey question.
Oh.
So major junior players, until, as you pointed out recently, were not allowed to transfer to teams within the NCAA. Now that's going to be permitted. What is the impact of that change going to have on the major junior clubs and league? And since those players, while they're major juniors, aren't subject to any NIL restrictions, whereas they would be when they go to the NCAA, yet they have a much greater opportunity for NIL if they become NCAA players. What impact is that going to have on the minor leagues, on the players who may be coming to the Sharks at some point in the future?
I think it's a great question. I'll tell you, my hockey knowledge wasn't great before I started at the Sharks. I've learned all this in the last 12 months. So if there's any gaps, you can let me know afterwards. But the fact that there was so many different junior leagues and that the sport has been spread across the continent, essentially, what I think one of the biggest impacts you're going to see is the growth of hockey in America. you see the World Cup game. The NHL itself has basically gotten rid of the All-Star game in favor of the Four Nations game, which is U.S., Canada, Finland, Sweden. It's leaning into this idea that this is an international sport dating back to the Miracle on Ice in the 80s, and we want to recapture that in America. So now even if you're from Vancouver, you're from Abbotsford, wherever you're from, you may want to play on what you consider to be the largest stage, which is most likely a Michigan or a Penn State or a Boston University, not only because you're getting equivalent levels of training, because they've got great facilities. Marshall can speak to the quality of facilities in the D1 world, probably outpace most of the major league sports in basketball and in football. And I think that's the plan in hockey, is to start investing in those sports at the D1 level, so that if you are making that decision and you're Canadian born or you're from Russia or Sweden, wherever you are, that you view the NCAA as the de facto, the end all be all, where you want to showcase your skills, not only because of the chance to build your market and your NIL value, but because this is where the best players play. So I think that's where it's going to be heading in the next 5 to 10 years, I hope.
All right, this question I think is probably best suited for Marshall and Kevin. A point you both touched on in this discussion was, how much stronger NIL valuations tend to correlate with virality of an athlete as opposed to athlete skill. I'm curious to that end. Has that virality aspect impacted, how you guys go about recruiting in terms of seeking out perhaps individual athletes in any cases based on, a criteria of virality of the individual?
Yeah, that's a good question. We purely looked at the tape and talent first and foremost, to be honest. But I do think that can save you some money on the back end from your rev share side. So being able to coordinate some of these deals to open up more cap space per se, and make connections to, look, hey, we got a great relationship with Levi's, so how about, we'll connect you with Mr. Haas, and then you go from there. If you have a deal, you have a deal with like a good, idea of like, we think a deal could, fall in this range, and it could save on the cap, letting us, allowing us to be able to go get a player that, is less of that virality type sense, the O-line, D-line, those kind of players. So I do think it plays a part in it for sure. Is this something we look at right off the bat? Probably not, but it is a part of the equation for sure.
Hi, I'm really kind of stunned about how in both the first panel and this panel, there's been no mention of Title IX. And I really want to ask about that, because it is true the San Jose Sharks are a company that is a private business, and they can allocate the money however they want. But Cal isn't. Cal is an educational institution that receives money from the federal government. Yeah. And because it does, it is required by Title IX not to discriminate on the basis of sex throughout the entire program. And in most of the program, that's easy, because you can't have a separate program of math for science for women and men. But in sports, it's the one area where you do. And Title IX law is very clear. If you have separate programs for men and women, which Cal does and all the other colleges do, the women and men have to be given equal opportunities to play, equal athletic financial aid, and most important here, equal treatment. Which means if you're spending $20.5 million, basically half of it's got to go to the women.
That was a theory.
That is not just a theory, but it's increasing law. And in terms of benefits, whether you call it the money has to go there, the law is clear. You have to treat the men and women equally.
Yeah. Well,
now, let me just...
No, please.
So my question is, how do you, particularly, Kevin, you said they could give all $20.5 million to a quarterback. I don't think that's correct under the law, unless you're separately treating some women equally. But my real question is how, Marshall and Kevin, how do you see Title IX fitting into this? Because this school is not just a private business and can't do what the Sharks do.
Right. So I mentioned there were some legally problematic, issues with what was going on with the House settlement, focused on antitrust. But the other is Title IX. And the House settlement, just for benefit of those in the room, actually was set. There's two components to the House settlement. One was historical damages for the student athletes who were within the statute of limitations, and then there was kind of proscriptive, like what was going to happen on a go-forward basis. So people took what was done for the historical settlement, and they extrapolated that and started doing the forward-looking payments. The historical settlements that was approved by the district judge was 75% football, 15% men's basketball, 5% women's basketball, and 5% all the Olympic sports, everyone else. So that gets you to your 100%. So you see right there, the case that went through was absolutely done not on a Title IX compliant basis. And in the final days of the Biden administration, the Department of Justice issued a ruling saying, hey, Title IX applies. Day one, Donald Trump overturned it.
The reason the judge said that distribution of the past money was okay is because she found the money was not being paid by the schools. It was being paid by non-educational institutions to which Title IX did not apply.
Right.
It specifically said, if the schools are distributing the money, including the $20.5 million, then Title IX's there.
Yeah.
So any school that is basing its distribution on what the NCAA was allowed to pay in damages and what the conferences were allowed to pay in damages, because Title IX did not apply to them, doesn't allow the schools to do this. And that's, if the justification is the schools can do whatever they want because they did it with the past House damages, I just think it's legally wrong.
Yeah.
I also wonder, if it does apply, what do you all think the schools have to do?
Well, I think there's a practical issue, and then there's also the theoretical issue. I mean, there is actually, there is debate still. I mean, I think there are some people who are debating, that the point you just made about kind of the obligation to comply is an opportunity issue, it's a revenue share, et cetera. I understand exactly what you're saying, and this has been debated quite a bit, and it's part of the entire basis with the Department of Justice and kind of their various pronouncements. The practical issue in the near term is that if everyone else is kind of doing 75% football, 15% men's basketball, there is no way to actually field a competitive team if you're actually going to do a strict Title IX compliance. So it's got to be all or nothing. So this is where you come back to, there has to be, and that's part of what the SAFE Act is, right? As opposed to the SCORE Act. So the two different competing versions of legislation have a different vision of how you're going to reconcile Title IX with all this. But right now, it's above my pay grade. but right now, this is the world in which we're living, I suppose. Is that there is no school, and Marshall, tell me if I'm wrong, there's no school that's doing Title IX, fully compliant Title IX payments at the Power 4 level. Zero.
Yeah, not to my knowledge, and above my pay grade too, for sure.
Great. Can we have a round of applause for the panel? That's great.